Before we begin, a quick and important disclaimer. The content provided in this video is for educational and informational purposes only and does not constitute legal, financial, or psychological advice. Divorce proceedings, family law, and the social science metrics discussed here are subject to varying state laws and individual circumstances. You should not act or refrain from acting on the basis of any content included in this video without seeking the appropriate legal or professional advice from a licensed attorney or qualified expert in your jurisdiction. The historical trends and case studies presented are used to illustrate social science concepts and do not represent individual outcomes. Please conduct your own due diligence before making significant life or financial decisions. The American marriage is currently facing its most significant structural shift in over half a century, but it is not the story you have been told by mainstream media. You have heard the statistic that 50% of marriages end in divorce, a figure that has been echoed in every sitcom and news cycle since the 1980s. However, when we look through the lens of Social Science's 661, a deep dive academic framework into the longitudinal data of American domesticity, we find that this number is not only outdated, but it also masks a much more complex and startling reality. We are witnessing a divergence in the U.S. social fabric where the factors of education, geography, and socioeconomic status are creating a two-tiered system of marital stability. This is the 661 analysis, and what it reveals about the next decade of American life is something that will fundamentally alter how you view your relationships, your finances, and your future. We are currently observing an open loop in the data. While divorce rates for the general population are technically declining, the complexity and the stakes of these legal separations are reaching an all-time high. Why is the divorce rate falling for some, while for others the legal and social fallout is becoming more catastrophic? Today, we are beginning a 10-part masterclass on the social science of divorce in the United States. By the time we finish this first segment, you will understand the invisible architecture of your own relationship and the hidden sociological pressures that either bind a household together or tear it apart. This video is designed to solve a specific, high-stakes problem for the American viewer: the lack of clarity regarding the modern landscape of family law and social expectations. If you feel like the traditional rules of the American dream are shifting beneath your feet, you are right. We are going to look at why the midlife transition has become a flashpoint for litigation, how the silver tsunami of gray divorce is draining retirement accounts across the country, and what the latest social science tells us about the potential outcomes of domestic partnerships in a post-pandemic economy. To understand the current state of Divorce 661, we must first deconstruct the history of the no-fault revolution. Before 1969, if you wanted to exit a marriage in the United States, you had to prove fault. You needed evidence of adultery, abandonment, or extreme cruelty. This created a legal bottleneck that kept marriage rates high but domestic satisfaction metrics low. When California passed the Family Law Act of 1969, signed by then-Governor Ronald Reagan, it triggered a domino effect across the country. This historical trend moved the U.S. from a fault-based system to a no-fault system, where a spouse could simply cite irreconcilable differences. Social science researchers in the 661 category point to this moment as the Great Decoupling. Data from the 1970s and early 1980s shows a massive spike in divorce filings as decades of suppressed domestic tension were finally released into the court system. But the 661 framework asks a deeper question: what happened after the spike? If we look at the data from 1990 to 2026, we see a fascinating and disturbing trend. Education has become the primary predictor of marital longevity. According to longitudinal studies, college-educated couples are seeing divorce rates that are significantly lower than they were in the 1970s. Meanwhile, for those without a four-year degree, the rates remain stubbornly high or are even increasing in certain rural demographics. This is what social scientists call the marital divide. It suggests that marriage in the U.S. is increasingly becoming a luxury good, a stabilized institution for those with the financial resources to outsource domestic stress. Let's look at a case study to illustrate how this functions in real time. Consider a dual-income household in a metropolitan area like North Dallas or Northern Virginia. Under the 661 analysis, this household is protected by what we call protective buffers: access to mental health resources, the ability to hire domestic help, and the fiscal cushion to weather a job loss. When these buffers are absent, the social science shows that the friction of everyday life translates directly into legal conflict. In these scenarios, divorce is not just a personal choice. It is often a systemic reaction to economic volatility. Furthermore, we must address the phenomenon of the gray divorce. This is a specific subset of the 661 study that focuses on couples over the age of 50. While divorce rates for younger generations are actually stabilizing or declining, the rate for those in the 50-plus demographic has nearly doubled since the 1990s. This has massive implications for the U.S. economy and the social safety net. When a couple divorces at age 65, they are essentially splitting a retirement fund that was calculated for a single household. The historical trends show that this leads to a sharp increase in poverty for older women and a significant strain on adult children, who must now provide care for two separate households. In this deep dive, we are also going to explore the psychological impact of the 661 metrics. We often talk about the financial cost of divorce, the legal fees, the mediation, the division of assets, but the social science highlights the cognitive load of a domestic transition. Researchers use the term transition shock to describe the 18-month period following a filing. During this time, the individual's productivity, health markers, and social engagement levels fluctuate wildly. By understanding these historical trends, you can begin to see that what feels like a personal failure is often a predictable outcome of specific social and economic pressures. As we progress through this series, we will break down the step-by-step mechanics of how the U.S. legal system interacts with these social science findings. We'll look at how custody arrangements have shifted from the tender years doctrine to the modern standard of the best interests of the child. We will examine how the definition of marital property has expanded to include things like professional degrees, intellectual property, and even digital assets like cryptocurrency. The promise of this masterclass is simple. Knowledge is the only hedge against volatility. Whether you are currently in a stable marriage, considering a separation, or navigating the aftermath of a divorce, understanding the 661 social science framework is essential. It allows you to move away from the emotional noise of the situation and look at the data-driven reality of how families function in the modern United States. We aren't just talking about the end of a contract, we are talking about the reorganization of a life. Consider the impact of social media and the digital age on these metrics. Recent case studies suggest that the hypervisibility of alternative lifestyles and the ease of reconnecting with past acquaintances via social platforms have introduced a new variable into the 661 equation. We are seeing a decrease in the barrier to exit. In previous decades, the social cost of divorce included a certain level of isolation or community stigma. Today, that stigma has largely evaporated in most U.S. demographics, replaced by a digital support network that can actually accelerate the decision to file. We will also look at the fiscal reality of the divorce industry itself. It is a multi-billion-dollar sector of the U.S. economy. From forensic accountants who hunt for hidden assets to child custody evaluators who charge thousands of dollars for a single report, the business of breaking up is one of the most recession-proof industries in America. By analyzing the 661 data, we can see how the cost of litigation often scales with the complexity of the assets, sometimes resulting in a situation where the only people who win are the professionals involved in the process. This first part of our deep dive sets the stage. We have moved past the era of simple explanations. The Divorce 661 framework requires us to look at the intersection of law, economics, and psychology. It requires us to be honest about the fact that the American family is in a state of flux. Over the next 9 segments, we will peel back the layers of this complex topic, providing you with the data and the case studies you need to understand the potential outcomes of the most significant social shift of our time. Stay with us as we move into the actual mechanics of the filing process and the sociological triggers that lead a person to say it's over. We are looking at the exact moment the threshold is crossed. In the 661 framework of social sciences, we refer to this not as a sudden and unpredictable break, but as the culmination of microfrictions. It is the sociological concept of the tipping point. Mainstream narratives often focus on catastrophic events like infidelity or severe financial ruin as the primary catalyst for a marital dissolution. However, the longitudinal data and historical trends paint a very different picture. The vast majority of filings in the United States do not stem from a single explosive event, but rather from a slow erosion of the domestic partnership ecosystem. We are examining what sociologists call the accumulation of unresolved systemic stress. Imagine if you are looking at a typical household in a suburban area of the Midwest in the year 2026. Let us consider the case study of Robert and Jessica. They represent the median demographic in our social science analysis for this current cycle. They are a dual-income household managing a modern hybrid work schedule, raising 2 children, and navigating the standard inflationary pressures of the current decade. The trigger for their dissolution is not a dramatic betrayal. It is what researchers in the 661 study identify as the invisible labor imbalance, heavily compounded by ambient economic anxiety. Jessica carries the vast majority of the cognitive load required for household management, a metric that remains stubbornly unbalanced despite shifts in modern gender roles. Meanwhile, Robert is absorbing the acute stress of corporate restructuring trends that are highly prevalent in the 2026 labor market. The social science data shows that this specific combination of internal imbalance and external pressure creates a slow-burning resentment. Over a period of 3 to 5 years, this resentment supersedes the structural and financial benefits of remaining in the marriage. The tipping point is reached and the decision is made. But what happens next is where the theory of sociology collides with the brutal mechanics of the American legal system. The filing process is not merely the signing of a document. It is the formal initiation of a complex adversarial cascade. Step 1 involves the petition for dissolution. One party, in this case Jessica, becomes the petitioner, while Robert becomes the respondent. This immediate categorization instantly shifts the dynamic from a partnership to opposing sides of a legal equation. The petition must establish jurisdiction, state the grounds for divorce, which as we established is almost universally no-fault irreconcilable differences, and request specific relief regarding assets, debts, and child custody. When Robert receives the official summons, historical trends indicate a highly predictable psychological response pattern. The respondent typically experiences acute transition shock, characterized by denial, reactive anger, and a sudden frantic scramble for legal representation. Jessica, having initiated the process, is typically 6 to 12 months ahead of Robert in terms of emotional processing. This is a well-documented phenomenon in the 661 literature known as the pre-grieving phase. This asymmetry in emotional readiness is one of the primary drivers of initial hostility and inflated legal costs during the first 90 days of the process. Once the petition is filed and served, the couple enters step 2, which is the discovery phase. This is where the 661 analysis shows the absolute highest concentration of systemic conflict. Financial uncoupling in the year 2026 is an extraordinarily intricate process. It is no longer a matter of simply dividing a joint checking account and assessing the equity in a primary residence. Modern discovery requires tracking complex digital footprints. It involves analyzing automated investment portfolios, uncovering fractional real estate investments, evaluating gig economy income streams, and tracing decentralized assets like cryptocurrency wallets. The financial transparency required by the court forces a complete audit of the marital estate, often uncovering financial realities that one partner was entirely unaware of. The potential outcomes during this phase are heavily dependent on the couple's ability to compartmentalize emotional trauma from financial reality. When they cannot, the discovery process becomes a weaponized mechanism. Forensic accountants are deployed not just to find hidden assets, but to aggressively value businesses, professional practices, and future earning potentials. Every request for document production, every interrogatory, and every deposition adds thousands of dollars to the cumulative cost of the dissolution, directly draining the very marital estate the parties are fighting to secure. Furthermore, we must examine the friction points of the immediate separation. The court process takes time, often 12 to 18 months or more in congested jurisdictions. During this interim, the legal system relies on temporary orders to govern the lives of the parties. Who remains in the primary residence? Who assumes the burden of the mortgage payments? How are the joint debts serviced while the household income is suddenly required to support two separate living arrangements? In 2026, with housing market inventory still presenting significant barriers to geographic mobility, we are observing a massive statistical rise in a phenomenon known as nesting. In a nesting arrangement, the children remain stationary in the marital home, and the parents rotate in and out of the residence according to a schedule, often renting a small secondary apartment to share during their off-duty days. While nesting is often presented as a child-centric solution designed to minimize disruption, the 661 social science metrics suggest the potential outcomes are highly volatile. Case studies reveal that nesting frequently prolongs the emotional entanglement of the divorcing couple, creating an environment ripe for ongoing conflict over the maintenance of the home and the adherence to boundaries. It is often an economic necessity masking itself as a psychological strategy. This brings us to the critical divergence in the procedural path. The couple must essentially choose between a mediated settlement and traditional litigation. The historical trends heavily favor alternative dispute resolution, as mediation preserves wealth and allows for customized agreements that the rigid legal code cannot accommodate. Yet, a significant percentage of cases still inevitably default to traditional litigation. The social science explains this by pointing to the inherent design of the legal infrastructure, which is built upon an adversarial model that naturally escalates disputes rather than resolving them. As Robert and Jessica navigate the brutal realities of financial discovery and temporary living arrangements, they are rapidly depleting their financial reserves and their emotional bandwidth. But the division of checking accounts and the sale of a suburban home are relatively simple equations compared to what comes next. The true test of the 661 framework, and the phase that generates the most profound, lasting trauma, involves the reorganization of the family unit itself. As the financial dust begins to settle, a far more intense battleground emerges, one where the stakes are not measured in dollars, but in hours, days, and the fundamental right to parent. We must now turn our attention to the most complex and heartbreaking element of the American legal system, the battle for the custody of the children, and how the state determines who gets to raise them. When the state steps into your living room to determine the fate of your children, the sterile legal environment suddenly becomes intensely personal. In the 661 social science framework, we observe that the dissolution of the marital contract is relatively straightforward compared to the severing and restructuring of the parental bond. For decades, the United States legal system relied on the tender years doctrine, a legal principle that overwhelmingly favored placing young children with their mothers. However, as longitudinal social science data evolved and cultural norms shifted, the courts adopted a new, far more complex standard known as the best interests of the child. While the best interest standard sounds perfectly equitable on paper, the historical trends and empirical data reveal a chaotic and highly subjective reality within the courtroom. The courts are essentially asked to predict the future psychological and developmental outcomes of a child based on a snapshot of a family in its most dysfunctional state. Judges, who are legal professionals and not developmental psychologists, must weigh factors such as the emotional ties between parent and child, the capacity of each parent to provide a stable environment, and the historical division of caregiving responsibilities. This is where the sociological concept of the primary attachment figure becomes the central battleground of modern family law. Imagine if you are looking at a custody dispute in the year 2026. Let us examine the case study of Michael and Sarah, a couple residing in the Pacific Northwest. Both are employed in high-demand sectors, utilizing the hybrid remote work model standard in the current economy. On the surface, they appear to share the parenting load equally. However, when the petition for dissolution is filed, the fight for physical custody exposes the hidden fault lines of their domestic life. Sarah argues that she carries the invisible cognitive load of parenting, managing medical appointments, educational tracking, and emotional regulation for their two children. Michael counters that his flexible schedule allows him to be physically present for daily routines and extracurricular activities just as frequently. In many jurisdictions today, there is a legal presumption toward equal shared physical custody. The social science data strongly supports the potential outcomes of equal access, showing that children generally fare better academically and psychologically when both parents remain actively involved. But the application of this presumption in the real world is fraught with friction. When Michael and Sarah cannot agree on a parenting plan, the court does not simply split the baby. Instead, it delegates the investigation to third-party professionals, introducing a staggering new level of expense and vulnerability into the process. Enter the guardian ad litem and the child custody evaluator. These are mental health professionals or specialized attorneys appointed by the court to conduct an exhaustive investigation into the family dynamics. The 661 research highlights this phase as the most invasive and traumatic component of the entire legal procedure. The evaluator will conduct extensive clinical interviews with Michael, Sarah, and the children. They will administer standard psychological assessments, such as the Minnesota Multiphasic Personality Inventory, to screen for personality disorders, severe depression, or erratic behavior patterns. They will perform home observations to judge the suitability of each living environment. They will even conduct collateral interviews with teachers, pediatricians, and neighbors. The potential outcomes of these evaluations carry immense weight. The judges heavily rely on the final written report to issue their custody orders. Consequently, The evaluation period often transforms into a theater of hypervigilance and weaponized psychology. Parents are instructed by their legal counsel to meticulously document every perceived failure of their co-parent. A missed pickup time, a forgotten lunchbox, or an ill-advised text message is no longer a simple human error. It becomes a documented data point presented to the evaluator as evidence of parental unfitness. The social science metrics show a dramatic spike in parental anxiety and depression during this exact phase, as the fear of losing access to one fragile ecosystem triggers the most primal survival instincts. Furthermore, the 661 framework forces us to confront the uncomfortable intersection of physical custody and financial leverage. In almost every state, the child support algorithm is inextricably linked to the number of overnights a child spends with each parent. The historical trends reveal a disturbing pattern where the fight for equal custody is sometimes less about parenting time and more about mitigating financial exposure. If Michael secures exactly 50% of the overnights, his monthly child support obligation to Sarah may drop significantly, or even disappear entirely, depending on their respective incomes. This creates a deeply problematic incentive structure. Social scientists refer to this as the commodification of parenting time, where days on a calendar are treated as financial assets to be negotiated and traded. As the litigation drags on, the psychological toll on the children becomes the most critical data point in the 661 analysis. Researchers monitor the rates of transition stress as children are shuffled between two separate households, forced to adapt to two different sets of rules, expectations, and emotional climates. We see rising instances of loyalty conflicts, where children feel compelled to align with one parent to alleviate the ambient tension. In extreme case studies, this escalates into parental alienation, a highly controversial and fiercely litigated dynamic, where one parent systematically undermines the child's relationship with the other. Identifying true alienation versus justified protective gatekeeping is one of the most difficult challenges facing the modern family court system. Eventually, the evaluations are completed, the financial resources are exhausted, and a final parenting plan is stamped by the judge. The legal decree outlines the exact schedule for holidays, summer vacations, and the logistical transfer of the children. It dictates who holds legal custody, which is the authority to make major decisions regarding education, religion, and medical care. The gavel falls, and the formal dissolution of the marriage is recorded in the county registry. The lawyers close their files. The forensic accountants move on to the next case. The courtroom doors swing shut. For Michael and Sarah, the legal war appears to have reached its conclusion. But the social science data from the 661 framework issues a stark warning about this exact moment. The final decree is not a finish line. It is merely the rulebook for a completely new, often highly volatile phase of existence. What happens when the rigid legal document collides with the unpredictable reality of raising human beings over the next decade? What occurs when one parent gets a promotion in another state, or a new blended family is introduced into the fragile ecosystem? We are about to step into the hidden multi-billion-dollar industry of post-judgment modifications, where the true long-term cost of a modern divorce is finally calculated. The ink on the final decree is dry, but the 661 social science framework reveals a startling historical trend. The most destructive phase of the American divorce often begins 2 to 3 years after the judge's gavel has fallen. We operate under the societal assumption that a divorce decree is a static, immutable resolution. It is fundamentally designed as a snapshot, a legally binding document that freezes a family's financial and emotional reality at a highly specific point in time. However, human lives are inherently dynamic. Children age and develop new needs, economies fluctuate, career trajectories pivot, and former spouses inevitably form new romantic attachments. When the rigid text of the final decree collides with the fluid reality of post-divorce life, the system fractures. This collision fuels the post-judgment modification industry, a highly lucrative sector of the family law system where the true, compounding costs of a dissolution are realized. To reopen a closed divorce case, the petitioner cannot simply express dissatisfaction with the original terms. The legal system requires a very specific trigger, universally known as a substantial and material change in circumstances. This legal threshold is deliberately designed to be high to prevent endless frivolous litigation, but in the volatile landscape of the year 2026, crossing this threshold has become increasingly common. A substantial change can be categorized into 3 primary domains: involuntary economic shifts, geographic relocation, and severe alterations in the psychological or physical well-being of the child. Imagine if we analyze the case study of Marcus and Chloe, residing in the metropolitan Atlanta area in 2026. 3 years ago, they finalized their divorce with a standard 50-50 shared parenting plan. Their agreement was predicated on the fact that they lived within 5 miles of each other, allowing their young daughter to seamlessly transition between households and attend her designated neighborhood school. However, the 2026 labor market is heavily defined by corporate consolidation and the retraction of remote work policies. Chloe, an executive in the logistics sector, is suddenly informed that her position is being relocated to a corporate hub in Dallas, Texas. If she declines the transfer, she faces immediate termination in a highly competitive market. This scenario triggers what family law practitioners and 661 researchers consider the most brutal and highly litigated post-judgment action in the United States legal system: the move-away case. Chloe files a petition for a post-judgment modification, requesting the court's permission to relocate with the child to Texas. Marcus immediately files a counterpetition to block the relocation and assume primary physical custody in Atlanta. The 50-50 compromise that sustained their fragile peace is instantly annihilated. The court cannot divide a child across 2 states. One parent will inevitably be reduced to an every other weekend and summer vacation role, effectively altering the trajectory of their parental bond forever. The mechanics of a move-away trial are agonizingly complex and financially devastating. Because the stakes are absolute, both parties are forced to re-engage legal counsel, often requiring initial retainer fees ranging from $10,000 to $25,000 each. The court must now conduct a granular analysis of the proposed relocation. They will examine the economic necessity of Chloe's move, the quality of the school districts in Dallas versus Atlanta, the presence of extended family support networks in both locations, and the historical depth of Marcus's relationship with his daughter. Social science data indicates that the geographical disruption index in these cases causes profound emotional regression in young children, who suddenly become the central evidence in a high-stakes geographic battle. The litigation process can easily consume a year, during which the child's future hangs in total suspension. Beyond relocation, the 661 metrics highlight involuntary economic shifts as the second massive driver of post-judgment modifications. Let us look at the financial dimension of Marcus and Chloe. Suppose instead of relocating, Marcus suffers a catastrophic job loss due to artificial intelligence integration in his specific engineering sector. His income drops from a 6-figure salary to relying on state unemployment benefits. He immediately files a motion for a downward modification of his court-ordered child support. Mainstream logic assumes that if you lose your job, your support obligations pause. The family court system, however, operates on a very different set of algorithms. Marcus encounters the devastating legal concept of imputed income. If Chloe's legal team can argue that Marcus is voluntarily underemployed, or that he is not making a sufficient, documented effort to replace his precise prior income, the judge possesses the authority to impute his previous salary. This means the court legally pretends Marcus is still earning his 6-figure income and holds him accountable for the corresponding child support payments. To defend against imputed income, Marcus cannot simply show his termination letter. The post-judgment economy requires him to hire a vocational evaluator. This specialized expert, costing thousands of dollars, will conduct a labor market analysis, review Marcus's resume, and testify in court about his actual employability and earning capacity in the specific 2026 regional economy. If Marcus fails to convince the judge, he will begin accumulating child support arrears. In the United States, child support arrears cannot be discharged in bankruptcy. They accrue massive interest, trigger the suspension of driver's licenses, result in the interception of tax refunds, and can ultimately lead to incarceration for contempt of court. The potential outcomes of a single economic downturn post-divorce can permanently exile a parent from the middle class. Furthermore, we must examine the introduction of the blended family. Historical trends show that a significant majority of divorced individuals will cohabitate or remarry within 5 years. When a new partner enters the ecosystem, the invisible boundaries of the original decree are immediately tested. Step-parents introduce new disciplinary styles, alternative financial resources, and often, new children into the mix. The 661 research refers to this as the expansion of the conflict matrix. A new marriage frequently acts as a sociological catalyst for one ex-spouse to drag the other back into court, masking emotional grievances about the new partner beneath legal petitions concerning right of first refusal for childcare or modifications to holiday schedules. This constant churn of post-judgment friction gives rise to a deeply concerning psychological phenomenon known as chronic litigation, or legal abuse syndrome. In highly conflicted dynamics, the family court system is actively weaponized. A well-resourced ex-spouse can continuously file minor contempt motions, discovery requests, and modification petitions, utilizing the judicial process to systematically bankrupt and psychologically terrorize the other party. The court system, bound by procedural rules, must process every filing, effectively becoming an unwitting participant in the ongoing domestic abuse. The true long-term cost of a modern divorce is not calculated on the day the decree is signed. It is calculated over the subsequent decade of legal skirmishes, vocational evaluations, and fractured geographic bonds. Families find themselves trapped in a cyclical drain of their cognitive and financial resources, enriching the modification industry while depleting the generational wealth intended for their children. But as these parents battle over schedules and monthly support algorithms, a massive ticking time bomb remains hidden deep within their financial portfolios. We must now turn our attention to the specific legal mechanism that destroys the American retirement dream, a system designed in the last century that is currently forcing thousands of older Americans back into the workforce. We are going to deconstruct the devastating reality of permanent spousal support and the division of the 401k. The ticking time bomb of the American divorce is often buried deep within the fine print of a retirement portfolio, specifically the 401k and the pension plan. In the 661 social science framework, we categorize this as the dissolution of future security. While the house and the car are tangible assets that can be appraised today, retirement accounts represent the invisible lifeblood of a person's final decades. When the state mandates the division of these accounts, it is not merely splitting a sum of money. It is fundamentally altering the velocity of compound interest and the statistical likelihood of a dignified retirement. To understand this, we must look at the legal mechanism known as the Qualified Domestic Relations Order, or the QDRO, and the shifting landscape of spousal maintenance in the year 2026. Imagine the case study of David and Emily. They have been married for 26 years. It is 2026, and they are part of the gray divorce wave. David is a senior project lead in the renewable energy sector, and Emily spent 15 years primarily managing the household before returning to work part-time as a specialized education consultant. Over nearly 3 decades, David's 401k has grown to a substantial $1.2 million. In the eyes of the law, because this wealth was accumulated during the marriage, it is considered marital property. The historical trends in the United States suggest that Emily is entitled to an equitable portion, which often results in a 50-50 split. However, the process of moving $600,000 from David's account to a new account for Emily is not as simple as a bank transfer. This is where the QDRO comes into play. A QDRO is a specialized court order that instructs a plan administrator to pay a portion of a retirement plan to an alternate payee. If this is not executed with surgical precision, the tax implications can be catastrophic. Under Internal Revenue Code Section 414P, a properly executed QDRO allows for the transfer of funds without triggering the 10% early withdrawal penalty or immediate income tax, provided the funds are rolled into another qualified plan. If a mistake is made in the drafting or if a spouse attempts to take the cash directly, the state will immediately treat it as taxable income, potentially losing 30 to 40% of the value to federal and state levies in a single afternoon. But the 661 social science analysis looks beyond the immediate tax hit. We must examine the math of compound interest. If David and Emily had stayed together, that $1.2 million would have continued to grow as a single massive principal. By splitting it into 2 separate $600,000 accounts, the growth potential for both individuals is severely hampered. They are no longer benefiting from the same scale of compounding. In the 2026 economy, where inflation remains a persistent variable, this reduction in principal often means that both David and Emily will have to work 5 to 7 years longer than they originally planned. The dream of retiring at 65 is replaced by the reality of the 70-year-old workforce. Now we must layer on the second major financial pillar, spousal support, commonly known as alimony. In the year 2026, the concept of permanent alimony is undergoing a radical legislative shift across many U.S. states, but for long-term marriages like David and Emily's, it remains a dominant force. The 661 framework identifies 3 primary categories of support: rehabilitative, durational, and permanent. Rehabilitative support is designed to provide a short-term bridge, perhaps 2 to 3 years, while a spouse like Emily gains the certifications or training necessary to become self-sufficient. Durational support is tied to the length of the marriage, often lasting for a percentage of the time the couple was wed. But permanent support, which is common in marriages exceeding 20 years, can last until the death of either party or the remarriage of the recipient. In our case study, the court looks at the marital standard of living. This is a sociological benchmark used to determine how much David must pay Emily, so that her lifestyle does not suffer a precipitous drop compared to what she enjoyed during the marriage. In 2026, the calculation of this support is more complex than ever. The court must factor in not just base salaries, but the value of health insurance, which has become a massive line item in domestic budgets, as well as stock options and performance bonuses. The social science data shows a phenomenon called the alimony trap. For David, the payer, the potential outcome is a significant reduction in his discretionary income, making it difficult for him to rebuild his own savings after the 401k split. For Emily, the recipient, there is often a sociological cliff. While the support helps, it is rarely enough to maintain the exact same household she once shared. She may find herself in a position where her income is too high to qualify for certain social subsidies, but too low to afford the rising property taxes on a family-sized home. Furthermore, we must address the 2026 reality of vocational experts in alimony disputes. When Emily argues that she can only earn $40,000 a year due to her time out of the workforce, David's legal team will hire a vocational evaluator. This expert will perform a labor market survey to prove that, with her background, Emily could actually be earning $80,000. The court may then impute income to Emily, reducing the alimony David is required to pay. This creates a high-stakes game of professional characterization where every past job title and every potential career path is scrutinized under a microscope. The cumulative effect of splitting the 401k and establishing long-term spousal support is what sociologists call downward mobility by decree. For the American middle and upper middle class, divorce at this stage of life is the single greatest destroyer of generational wealth. The money that was once destined for the college funds of grandchildren, or as an inheritance, is instead consumed by the friction of maintaining two separate households on a fund meant for one. As David and Emily navigate this, they are often blindsided by the emotional weight of the financial divestment. Seeing a retirement statement that has been cut in half is a psychological trauma that the legal system rarely acknowledges. It represents the death of a specific future, but as devastating as the retirement and alimony battles are, they are at least visible. They are negotiated in open court and recorded in the decree. However, the 661 framework warns of a much more insidious threat lurking in the shadows of the 2026 divorce landscape. Beyond the 401k and the monthly support checks, there is a hidden layer of financial entanglement that many couples completely overlook until it is too late. We are talking about the shadow debt, the forgotten liabilities, and the digital assets that can be used to siphon wealth long after the divorce is final. In our next part, we are going to dive into the world of forensic digital discovery and the terrifying reality of hidden marital liabilities that can haunt you for decades. What happens when your ex-spouse's debt becomes your legal nightmare? The answer lies in the dark corners of the modern credit system. The dark corners of the modern credit system are where the most sophisticated financial traps are laid during a high-stakes divorce. In the 661 social science framework, we refer to this as the liability overhang. Most people entering a dissolution in 2026 focus exclusively on the assets, the house, the retirement, and the liquid cash. But the historical trends show that it is the hidden liabilities, the shadow debt, and the digital paper trails that often dictate the long-term survival of each party. We are living in an era of decentralized finance and granular credit reporting, where a single oversight in the final decree can lead to years of financial domestic abuse after the marriage is legally over. Imagine the case study of Linda and Stephen. They finalized their divorce in early 2026 after 18 years of marriage. As part of their settlement, Stephen was awarded the family SUV and the responsibility for the remaining $30,000 on the auto loan. Linda was awarded the primary residence and the responsibility for the mortgage. On paper, it was a clean break. However, the social science data regarding credit architecture reveals a terrifying reality. The divorce decree is a contract between Linda and Stephen, but it is not a contract between Linda, Stephen, and the bank. Because both names were on the original promissory note for the vehicle, The lender does not care about the divorce decree. 6 months into his post-divorce life, Stephen experiences a financial setback and misses 3 consecutive car payments. The bank does not just go after Stephen. They report the delinquency on Linda's credit report. Her credit score, which she worked meticulously to maintain to facilitate her own housing transition, plummets by over 100 points in a 90-day window. This is the shadow debt trap. Even though a judge ordered Stephen to pay, Linda's financial reputation is held hostage by his performance. The potential outcomes of this situation are grim. Linda may be unable to refinance her mortgage or secure a necessary line of credit because of a liability she no longer legally owns according to the state, but still owns according to the credit bureaus. To navigate this in 2026, the 661 framework highlights a critical step-by-step detail that is frequently missed: the requirement for immediate indemnification and refinancing. A professional deep dive into this topic reveals that a well-drafted decree must include a hard deadline for the removal of the non-responsible spouse's name from all joint debts. If Stephen cannot refinance the SUV into his sole name within 90 days, the decree should mandate the immediate sale of the asset to satisfy the debt. Without this specific trigger, the liability remains a ticking time bomb for the other party. Furthermore, we must address the evolution of forensic digital discovery in the 2026 divorce landscape. We are no longer just looking at bank statements and credit card bills. Historical trends show that significant wealth is now being sequestered in non-traditional digital spaces. This includes high-value digital collectibles, earned but unvested tokens in tech startups, and gaming ecosystems that have their own internal economies. Consider a scenario where Stephen, a software developer, has been quietly accumulating assets in a decentralized finance protocol. Under the 661 social science lens, this is classified as marital property if the initial capital used was from marital earnings. However, finding these assets requires a level of digital forensics that traditional family law firms are only beginning to master. The process involves analyzing the metadata of family computers, tracing transfers to known exchange platforms, and looking for recovery seeds hidden in physical or digital vaults. If Linda's legal team fails to conduct a thorough digital audit, she could be walking away from 40% of the actual marital wealth without even knowing it exists. But hidden assets are only half of the digital nightmare. We must also look at the rise of coercive control through technology. In the year 2026, many households are fully integrated with smart technology. Thermostats, security cameras, door locks, and even kitchen appliances are linked to shared accounts. Case studies from the 661 research indicate a disturbing trend where one spouse uses these integrated systems to monitor or harass the other during and after the divorce process. This is the sociological extension of the domestic space into the digital realm. A deep dive masterclass on divorce must emphasize the necessity of a digital security audit as part of the separation process. This involves migrating all shared passwords, resetting hardware to factory settings, and severing the links between shared cloud storage accounts where private photos, locations, and communications are stored. The financial entanglement also extends to the IRS. In the United States, if you file a joint tax return, you are both held jointly and severally liable for the accuracy of that return and any tax, interest, or penalties that arise from it. If Stephen underreported his consulting income in 2024 or 2025 while they were still married, and the IRS conducts an audit in 2027, they will come after Linda for the full amount. The 661 analysis points to the innocent spouse relief provision under the tax code as a vital but difficult-to-attain protection. Linda would have to prove she had no knowledge and no reason to know of the understatement of tax. The legal fees to fight an IRS audit can easily exceed the tax bill itself, creating a situation where the divorce continues to drain the parties years after the decree. We must also examine the compounding effect of these liabilities on the next generation. The social science data shows that the financial instability caused by shadow debt and tax liabilities significantly reduces the parents' ability to contribute to their children's higher education. In 2026, as tuition costs continue to outpace inflation, the loss of these funds forces children into high-interest student loans, effectively passing the cost of the parents' divorce onto the children's future. As we look at the complexity of these issues, from credit score devastation to digital asset tracing and IRS liability, it becomes clear why the 661 framework is so essential. It shifts the perspective from a simple legal breakup to a comprehensive systemic restructuring. The divorce is not a single event. It is a long-term management of risk. But as we manage these risks, a new and perhaps even more complex variable is introduced into the equation. We have talked about the money, the kids, and the debt. But what happens when the very identity of the individuals involved begins to shift? In the 2026 social landscape, we are seeing a massive rise in what sociologists call late-onset autonomy. This is the moment where, after the financial and legal dust has settled, the individual must rediscover who they are outside of the marital unit. However, this process of self-discovery often leads back to the courtroom for one final, devastating reason. In our next segment, we are going to explore the psychological warfare of the long-term settlement. We will look at how the legal system is used to settle emotional scores, the reality of the forever war in high-conflict cases, and the specific strategies used by the most successful survivors of the 661 process to finally find peace. We are moving from the cold hard numbers into the complex machinery of the human mind and the final battle for personal freedom. What is the true price of peace in a system designed for conflict? The answer is more expensive than you think. The true price of peace in a system designed for conflict is often calculated in the currency of psychological endurance. In the 661 social science framework, we move beyond the ledgers of debt and the schedules of custody into the territory of high-conflict personality dynamics and the machinery of legal warfare. In the year 2026, the United States legal system remains fundamentally adversarial, a structure that rewards aggression and often penalizes the pursuit of a quiet resolution. When one party decides to use the courtroom as a stage for emotional retribution, the other party is forced into a defensive posture that can last for years. This is what we call the forever war of domestic litigation. Imagine the case study of Elena and Thomas. They have been divorced for 4 years, yet they have spent more time in a courtroom post-decree than they did during the initial filing. Thomas exhibits a pattern that social science researchers identify as the high-conflict personality, or HCP. In the 661 framework, an HCP is characterized by a preoccupation with blaming others, all-or-nothing thinking, unmanaged emotions, and extreme behaviors. For Thomas, the end of the marriage was not a conclusion but a transition into a new form of engagement. He uses the legal system to maintain a tether to Elena, filing motions for minor infractions that a reasonable person would overlook. In 2026, we see this play out through the weaponization of the right of first refusal. In their original decree, Elena and Thomas agreed that if one parent is unavailable for more than 4 hours during their parenting time, they must offer the other parent the opportunity to watch the children. Thomas begins monitoring Elena's social media and digital footprint with surgical precision. If he sees a photo of her at a professional seminar on a Saturday afternoon, he immediately files a contempt of court motion, alleging she violated the right of first refusal by leaving the children with her sister without notifying him. The historical trends in these cases show a devastating cycle. Elena must hire an attorney to respond to the motion. She must produce evidence of her whereabouts and the duration of her absence. The court, burdened by thousands of similar cases, eventually dismisses the motion as de minimis, or too small to warrant a penalty. However, Thomas has achieved his true objective. He has forced Elena to spend $3,000 in legal fees, caused her significant emotional distress, and reminded her that he still exerts control over her daily life. In the 661 analysis, this is classified as litigation abuse, a form of post-separation coercive control that the American judicial system is currently struggling to regulate. To understand the potential outcomes of this psychological warfare, we must look at the step-by-step reality of a high-conflict trial. When the conflict escalates to a full evidentiary hearing, the social science moves into the realm of personality assessments. In 2026, many family courts are increasingly utilizing specialized psychological testing beyond the standard MMPI. They are looking for traits associated with cluster B personality disorders, such as narcissism or borderline personality, which are highly correlated with chronic litigation. The process is grueling. Elena is subjected to a deposition where Thomas's attorney grills her for 6 hours on her parenting choices, her personal life, and her financial expenditures. Every text message she has sent in the last 3 years is scrutinized for signs of hostility. If she responds to Thomas's provocations with anger, that anger is presented to the court as evidence that she is an alienating parent. This is the reactive abuse trap. The 661 data shows that the high-conflict party often baits the other into an emotional outburst, then uses that outburst as legal leverage. The psychological toll of this constant surveillance leads to what researchers call the hypervigilance index. Elena begins to live her life in anticipation of the next filing. She stops posting on social media, she limits her social interactions, and she becomes obsessively meticulous about every minute of her parenting time. The social science indicates that this level of stress fundamentally alters the brain's cortisol production and can lead to long-term physical health issues, including autoimmune responses and chronic fatigue. The cost of the divorce is no longer just the legal fees, it is the erosion of Elena's well-being. Furthermore, we must examine the impact on the legal professionals involved. In the 2026 social landscape, we are observing high rates of secondary traumatic stress among family law attorneys and judges. When a system is designed for conflict, the people operating the machinery are inevitably affected by the vitriol. This often leads to judicial burnout, where a judge may become cynical or dismissive, inadvertently failing to recognize genuine cases of abuse because they have become desensitized by the constant stream of high-conflict petitions. So, how do survivors of the 661 process eventually find a path to peace? The data suggests a radical shift in strategy, known as parallel parenting. Unlike co-parenting, which requires frequent communication and collaboration, parallel parenting is a model designed for high-conflict scenarios where the goal is to minimize contact entirely. Step by step, the parties move toward a highly structured, rigid schedule where every detail is predetermined. In 2026, this is facilitated by court-monitored communication apps. These platforms replace traditional texting and emailing. All communication must be written, is archived for court review, and often includes AI-driven tone filters that warn a user if their message is likely to be perceived as aggressive. By moving the interaction into a monitored digital space, the 661 metrics show a significant reduction in the frequency of new legal filings. Peace is achieved not through reconciliation, but through the total compartmentalization of the two households. But even with parallel parenting, there is one final hurdle that many American families fail to anticipate. As the children grow older, the focus of the conflict often shifts from the day-to-day logistics to the long-term milestones. We are seeing a massive increase in litigation over secondary education costs and the funding of a college education. In some U.S. states, the court can order a divorced parent to pay for college, even if that parent has no relationship with the child. This creates a new financial cliff just as the parents are nearing retirement age. As we look at Elena and Thomas, we see a family that has been restructured by the law, but not healed by it. The 661 framework forces us to realize that the legal system is a blunt instrument for a delicate human problem. We have explored the money, the debt, the kids, and the psychological warfare. But as we move into the final chapters of this masterclass, we have to look at the global picture. How does the American experience of divorce compare to the rest of the world in 2026? And more importantly, what are the emerging trends that suggest the entire concept of the 661 framework is about to be disrupted by a new way of defining partnership? In our next part, we are going to look at the rise of the prenuptial economy and the end of the traditional marital contract as we know it. The future of American relationships is being rewritten in real time. And the new rules will surprise you. The rise of the prenuptial economy is not a trend driven by cynicism, but rather a calculated response to the extreme volatility we have documented throughout this 661 social science deep dive. Year 2026, the traditional view of a prenuptial agreement as a tool for the ultra-wealthy has been completely dismantled. Instead, we are seeing the emergence of the marital business plan. Younger generations, specifically older Gen Z and millennials, who have witnessed the systemic collapse of their parents' assets during the 2008 and 2020 economic cycles, are entering marriage with a defensive financial posture. They are moving away from the default state-mandated contract and toward a customized, private agreement that dictates the potential outcomes of a split before the emotional fog of a relationship even begins. Imagine the case study of Taylor and Jordan. It is 2026, and they are preparing to marry in Seattle. Taylor is a mid-level manager in a biotechnology firm with significant unvested stock options. Jordan is a freelance creative professional with a fluctuating income, but a substantial inheritance held in a family trust. In a traditional 661 scenario without an agreement, their marriage would instantly create a community property or equitable distribution nightmare. The moment Taylor's stock options vest during the marriage, they could be classified as marital property. If Jordan uses a portion of the inheritance to pay down the mortgage on their shared home, that separate asset becomes commingled, potentially losing its protected status. To prevent this, Taylor and Jordan engage in the prenuptial economy. This is a step-by-step process that begins with full financial disclosure. In the 2026 legal landscape, failing to disclose even a minor asset can render the entire agreement void. They must list every bank account, every debt, every digital wallet, and every prospective business interest. This transparency serves a sociological purpose. It forces a level of financial intimacy that many couples avoid until they are in the midst of a crisis. The agreement they draft is not just about who gets the house. It includes sunset clauses, which dictate that certain provisions of the agreement expire after 10 or 15 years of marriage, acknowledging that the nature of a partnership changes over time. It includes lifestyle clauses, which, while sometimes controversial, attempt to set expectations for domestic contributions. But most importantly, it establishes a formula for alimony that bypasses the unpredictable judicial discretion we analyzed in earlier parts. By setting a predetermined multiplier based on the length of the marriage, Taylor and Jordan eliminate the need for future vocational experts and forensic accountants. They are essentially opting out of the multi-billion-dollar divorce industry before they even enter it. The historical trends show that this shift is creating a two-tiered marital system in the United States. On one side, we have the regulated marriage, governed by aging state laws that haven't fully adapted to the gig economy or digital wealth. On the other side, we have the contract marriage, where individuals treat the union as a high-stakes merger. Social science data suggests that couples with these agreements often report lower levels of financial anxiety. Because the exit strategy is already defined, the financial power dynamics during the marriage are neutralized. They aren't staying together because they are afraid of the legal cost of leaving. They are staying together because the partnership continues to provide value. However, we must also look at the darker side of the prenuptial economy, the rise of the postnuptial agreement. In 2026, we are seeing a massive spike in couples who are already 5 or 10 years into a marriage suddenly seeking legal counsel to wall off assets. This is often triggered by a specific event, a sudden inheritance, a business startup, or the discovery of a partner's gambling or spending habit. The 661 framework identifies the postnuptial agreement as a desperate attempt to stabilize a rocking boat. Unlike the prenuptial, these agreements are scrutinized much more heavily by judges, as there is a higher risk of coercion when a person is already legally and financially bound to another. The expansion of this economy has also birthed a new professional class, the marital mediator. In the past, you hired a lawyer to fight. In 2026, you hire a mediator to architect. These professionals use the same 661 social science metrics to help couples visualize their financial future. They use software to model potential outcomes of different asset divisions over a 20-year horizon. This is the commodification of marital stability. We are seeing the death of the romantic ideal of marriage as a leap of faith, replaced by marriage as a risk-mitigated investment. But as Taylor and Jordan and millions of others rewrite the rules of the contract, the technology we use to find and maintain these relationships is introducing a variable that no prenuptial can fully account for. We are entering the era of the algorithmic divorce. In 2026, social scientists are beginning to track how predictive analytics and big data are being used by insurance companies, lenders, and even law firms to determine the probability of a couple's success. Imagine a world where your mortgage interest rate or your life insurance premium is tied to the statistical likelihood of your marriage surviving, based on your combined digital footprint. This is not science fiction. The data collected by dating apps, which many couples use to meet, is being archived and analyzed. The 661 framework is expanding to include the Digital Compatibility Index. If the algorithm sees that you and your partner have divergent spending habits, conflicting sleep patterns tracked by wearable tech, or a decrease in the frequency of positive digital interactions, the system flags you as a high-risk unit. We are seeing the first case studies where this data is being subpoenaed in divorce proceedings to prove a breakdown of the marriage long before the physical separation occurred. The implications for the American social fabric are profound. If your marriage is treated as a risk-rated asset by the economy, the pressure to maintain the appearance of stability becomes a new form of social control. We are moving toward a society where the cost of a divorce is not just the legal fees and the split retirement, but a permanent downgrade in your societal trust score. As we look at the rise of the prenuptial economy and the algorithmic tracking of relationships, we have to ask, what is the end goal? Is the American legal system evolving to protect the individual? Or is it simply finding new ways to monetize the failure of the family unit? We have covered the legal mechanics, the financial traps, the psychological warfare, and the new contract culture. But there is one final, overlooked demographic in the 661 study that is about to change everything. We have talked about the parents, the lawyers, and the experts. We haven't talked about the children of the 661 era, who are now reaching adulthood. In our next part, we are going to look at the generational fallout. We will examine the data on the first generation of children raised entirely within the high-conflict, digitally monitored, 50-50 shared custody model. How do they view marriage? How are they reshaping the U.S. economy to avoid the traps their parents fell into? The 661 metrics are about to hit a massive wall of generational resistance, and the results will redefine the American family for the next 50 years. We are going to look at the rise of the intentional non-marriage and the legal structures being built to support it. The most viral shift in U.S. social sciences is yet to come. The 661 social science framework is now recording its most significant data pivot as the children of the Great Divorce era come of age. In 2026, we are witnessing the emergence of the first generation of adults who were raised almost entirely within the context of high-conflict litigation and the 50-50 shared custody model. These individuals are not just observers of the system. They are the primary psychological subjects of its evolution. The data suggests that this cohort is developing a radically different relationship with the concept of the state-sanctioned marital contract. We call this the era of intentional non-marriage, a sociological movement that is rewriting the rules of the American household and forcing the legal system to create entirely new structures for domestic partnership. Imagine the case study of Alex and Samantha, both 30 years old, living in the tech-heavy corridor of Austin, Texas, in 2026. Both Alex and Samantha are children of highly litigious divorces. They watched their parents' retirement funds evaporate in the 2010s to pay for attorney retainers and forensic accounting. They remember the transition stress of shifting between two households every 3 days. Now, as they build a life together, they are making a conscious, data-driven decision to completely bypass the traditional marriage system. They are not remaining single. They are creating what social scientists call a high-stakes cohabitation. In previous decades, cohabitation was often seen as a casual precursor to marriage. In 2026, for the 661 demographic, it has become a permanent, structured alternative. However, because they are financially savvy and risk-averse, Alex and Samantha are not just living together under a verbal agreement. They are utilizing a legal instrument known as a cohabitation agreement or a domestic partnership contract. This is the secular, business-first version of marriage. It specifies how the mortgage on their shared townhouse will be handled if they separate. It dictates the ownership of their joint investment accounts and even outlines a private mediation process for any future disputes. The 661 metrics show that this shift toward intentional non-marriage is creating a massive ripple effect in the U.S. economy. Traditional institutions, from mortgage lenders to insurance providers, are being forced to adapt to the reality that a growing percentage of their high-value customers are not legally married. We are seeing the rise of joint tenancy and common agreements for home purchases, where the legal structure of the house ownership acts as a miniature, private divorce decree. If Alex and Samantha break up, the exit strategy is already hard-coded into the property deed. But the most fascinating aspect of this generational fallout is how it is affecting the labor market and career trajectories. The historical trends show that children of the 661 era are prioritizing extreme financial autonomy. Samantha, for instance, maintains a strictly separate investment portfolio that Alex cannot access. They use a joint account only for shared household expenses like groceries and utilities. This is the sociological phenomenon of the hyper-independent household. In the 2026 economy, this demographic is less likely to relocate for a partner's career and more likely to prioritize liquid assets over traditional real estate. They have learned that mobility is the ultimate defense against the financial paralysis of a messy legal separation. Furthermore, we must examine the impact of this movement on the birth rate and the structure of modern parenting. Within the 661 framework, we are seeing the rise of the elective co-parenting model. Some couples in this demographic are choosing to have children without ever entering a romantic or legal union. They are drafting parenting plans before the child is even born, treating the upbringing of the child as a collaborative project rather than a byproduct of a romantic contract. This allows them to avoid the best interests of the child litigation that we explored in Part 3. By codifying their expectations in a private contract, they are effectively insulating their children from the judicial system that traumatized them a generation ago. The social science data indicates that these intentional non-marriages often show higher levels of stability than traditional marriages in the same socioeconomic bracket. Researchers suggest this is because the relationship is sustained by daily, active choice rather than the legal and social inertia of a marriage certificate. When the barrier to exit is clear and predefined, the focus remains on the quality of the partnership. This is the ultimate subversion of the 661 system. By planning for the end from the very beginning, this generation is creating a version of commitment that is more resilient, because it is based on transparency rather than romanticized ambiguity. However, the U.S. legal system is not letting go of its control so easily. In response to the rise of intentional non-marriage, we are seeing an increase in the application of common law marriage doctrines and equitable distribution claims for long-term cohabitants. Even if Alex and Samantha never sign a marriage license, a court in 2026 might still decide that their long-term, intertwined lives constitute a legal union for the purposes of asset division. This is the final frontier of the 661 struggle, the battle between individual autonomy and state-enforced domestic policy. We are also observing the rise of digital legacy planning among this generation. Alex and Samantha are not just concerned about their physical assets, they are concerned about their digital estates. They have legal agreements governing the access to and ownership of their shared digital content, from cloud storage to high-value social media accounts and virtual real estate. In the 2026 landscape, your digital footprint is often your most valuable asset, and the 661-era children are the first to treat it with the same legal gravity as a 401k. As we analyze this generational shift, it becomes clear that the traditional American divorce is becoming obsolete because the traditional American marriage is being fundamentally redesigned. The high-conflict, high-cost model of the last 50 years is hitting a wall of absolute resistance. The next generation is choosing a path that prioritizes peace, autonomy, and financial security over the institutional rituals of the past. They are moving toward a world where every relationship is a custom-built contract, and every exit is a pre-calculated maneuver. But this new era of hyper-rational relationships brings its own set of questions. If we remove the social and legal weight of marriage, what happens to the social safety net? Who takes care of the vulnerable partner in a non-marriage when things go wrong? And how will the state collect taxes and manage social benefits in a society where the household unit is constantly being redefined and uncoupled? We have reached the edge of the 661 framework as we know it. In our final concluding part of this masterclass, we are going to pull all these threads together. We will look at the 2026 roadmap for the future of the American family. We will provide the final deep dive synthesis of how to navigate the current system while preparing for the inevitable shift toward the new domestic economy. We are going to reveal the one final shocking statistic that most social scientists are afraid to discuss. It is the data point that explains why everything you thought you knew about divorce is about to be flipped on its head. Stay with us for the final part of Divorce 661, the Great Transformation. The final shock to the system, the data point that social scientists in the 661 framework have been monitoring with increasing intensity as we move through 2026, is the complete inversion of the Divorce Motivation Index. For decades, the primary driver of divorce was internal friction, essentially the pursuit of individual happiness, or the escape from domestic dysfunction. But in the current U.S. social landscape, we are observing a massive statistical rise in what is being termed the strategic or fiscal divorce. This is a phenomenon where couples who are interpersonally stable, and who may even remain romantically involved in cohabiting, choose to legally dissolve their marriage for the sole purpose of navigating the systemic failures of the American healthcare and education systems. Consider the case study of Kevin and Maria, a couple in their late 50s living in Pennsylvania. They have been married for 30 years and have a stable relationship. However, Kevin has recently been diagnosed with a chronic, progressive neurological condition that requires long-term specialized care. Under current 2026 U.S. social policy, if they remain married, their combined assets, the house they spent decades paying off, their shared retirement accounts, and their savings, must be almost entirely depleted before Kevin becomes eligible for certain state-funded long-term care benefits. To protect Maria from total financial indigence, and to ensure the family home remains an asset for their children, they undergo a strategic divorce. In this scenario, the 661 framework is no longer analyzing the breakdown of a relationship, but the tactical deconstruction of a legal entity to survive an economic reality. The court oversees the division of assets, shifting the majority of the liquid wealth and the primary residence to Maria as part of the settlement. When Kevin eventually requires full-time institutional care, he applies as a single individual with limited assets. This is the great transformation, the legal end of a marriage used as a shield against the cost of aging. Social science data indicates that this is not an isolated trend. It is becoming a standard financial planning strategy for the American middle class who find themselves caught between the high cost of private insurance and the strict asset limits of public assistance. The potential outcomes of this shift are profound for the American social fabric. We are entering an era where the legal status of marriage is being decoupled from the lived reality of the family unit. This creates a massive data distortion for the U.S. Census and other sociological metrics. If thousands of couples are legally divorced but remain domestic partners, our understanding of poverty rates, household income, and social stability is fundamentally compromised. But the strategic divorce is not limited to the aging population. We are seeing a secondary spike among parents of college-aged children. Imagine if we look at the case study of Brian and Sarah. Their daughter is applying to high-tier private universities where the annual cost of attendance in 2026 has crossed the $95,000 mark. Because Brian and Sarah are a dual-income household, their expected family contribution is calculated at a level that makes them ineligible for significant need-based aid, yet they do not have the liquid cash to pay nearly $400,000 for a 4-year degree. By legally divorcing and ensuring the child resides primarily with the lower-earning parent, they can significantly alter the financial aid algorithms. This is the step-by-step gamification of the 661 social science framework. The legal system, designed to handle domestic disputes, is being repurposed into a financial bypass for a broken economic infrastructure. It forces us to ask, if the only way to afford healthcare or education in the United States is to legally dismantle the family unit, what does the future of the American institution of marriage actually look like? Historical trends suggest that when a legal institution becomes a liability rather than an asset, the population will simply stop participating in it. This brings us to the final synthesis of our masterclass. We have tracked the evolution from the no-fault revolution of the 1970s to the high-conflict litigation of the 2000s, through the digital and algorithmic era of the 2020s, and finally to the strategic deconstructions of 2026. The overarching theme of Divorce 661 is the move from a moral or emotional event to a purely mechanical and fiscal one. The roadmap for the future is clear. We are moving toward a modular society. In this new world, individuals will not sign a single, all-encompassing marriage contract provided by the state. Instead, they will assemble a suite of private legal documents: a cohabitation agreement for property, a private parenting plan for children, a healthcare proxy for medical decisions, and a digital asset trust for their online presence. This modular approach allows for the same level of commitment and protection as traditional marriage but without the catastrophic, all-or-nothing fallout of a state-sanctioned divorce. The 661 framework is now shifting its focus to the legislative responses to this movement. There is already significant debate in state capitals about the reform of the divorce code to address these strategic filings. Some propose a clawback period for assets in cases where a couple remains cohabiting after a divorce, while others suggest a total overhaul of how assets are counted for social benefits, which would eliminate the need for strategic divorces in the first place. As you navigate this landscape, the ultimate takeaway of this masterclass is the necessity of radical transparency and lifelong legal literacy. The days of assuming that the law will provide a fair or intuitive outcome are over. Whether you are entering a relationship, maintaining one, or exiting one, you must treat your domestic arrangements with the same level of scrutiny as a professional business partnership. The most successful survivors of the 661 era are those who recognize that the family is an economic unit as much as an emotional one. The 2026 data shows that while the divorce rate may be fluctuating, the complexity of domestic separation is at an all-time high. We have covered the forensic accounting, the psychological traps, the hidden debts, the generational shifts, and the strategic maneuvers. You now have the deep dive framework to understand the invisible forces at play in every American courtroom and every suburban living room. The story of the American family is not ending. It is being rewritten in a language of contracts, data points, and strategic pivots. This is the great transformation. The question is no longer whether your marriage will survive, but whether you have built a life that can survive the legal and economic systems designed to manage its failure. As we conclude this 10-part masterclass, we are opening a new loop for our next series. We have looked at the deconstruction of the family, but what happens when the state itself begins to intervene in the digital identity of its citizens? We are preparing a deep dive into the 662 framework, the social science of digital citizenship, and the rise of the social credit economy in the United States. If you thought the divorce court was invasive, wait until you see how your digital reputation is about to determine your physical freedom. That masterclass begins in our next upload. The data is already being collected. The transition has already begun.